So what is intellectual property? Intellectual property refers to creation of the mind such as invention, literary artistic works, design and symbols, name and images used in commerce. So it is according to WIFO, and it is protected in law by, for example, patents, copyright, and trademarks. So intellectual property has been created by human's mind. Either it is intellectual or creative. And intellectual property also considered as intangible asset. Why is it considered as intangible asset? So for example, a company brand's name, it considered as intangible asset because it stays with the company for as long as it continues operation. So the owners of intellectual property have exclusive rights that are protected against unauthorized use for certain periods of time. So take note that anything that you can create using your mind is considered as intellectual property. So how about the intellectual property rights? So intellectual property rights, it is a right held by a person or by a company to have exclusive right over this. So this encourages innovation without the fear that a competitor will steal the idea and or take credit for it. So intellectual property rights are the rights given to a person over the creation of their minds. They usually give the creator an exclusive right over the use of his work. So, ang lahat ng gawa ng tao ay nasasakop sa intellectual property rights. So, in our country, we have the Intellectual Property Office of the Philippines, or the IPOPIL, which administer and implements state policies in relation to intellectual property. So this office was created through Republic Act 8293. So this act defines intellectual property to include copyrights and related rights, trademarks and services mark, geographic indication, industrial design, patents, layout design, or topographies of integrated circuits, and protection of undisclosed information.
Copyright. Okay, so when we usually scroll through the internet or even in books, most of us have seen the word or the symbol copyright hundreds of times, right? But what does it actually mean? Copyright refers to the legal right given to the owner of the original work or the intellectual property. These works are original intellectual creations in the literary and artistic domain protected from the moment of their creation, which include the following. First things first, books, pamphlets, articles, and other work environments. Some of us may not know where copyright is printed in a book, but usually it is printed in the back of the title page. Also, some of us may not know that word was important for the original creators, because some of us wouldn't go through references and references. We usually go through the main part of the book or the main story itself. Second, periodicals and newspapers. Lectures, sermons, addresses, dissertations prepared for oral delivery, whether or not reduced in writing or other material forms, or letters. Number 5, dramatic or dramatical musical compositions, choreographic works, or entertainment in film shows. 6, musical compositions with or without words. 7, works of drawing, painting, architecture, sculpture, engraving, lithography, or other works of art. Models or designs for works of art. 8, original ornamental designs or models for articles of manufacture, whether or not registrable as an industrial design and other works of applied art. 9. Illustrations, map plans, sketches, charts, and three-dimensional works related to geography, topography, architecture, or science. 10. The drawings are plastic works with scientific or technical character. 11. Photographic works, including works produced by a process analogous to photography, lantern slides. 12. Audiovisual works and cinematography works. 13. Pictorial illustrations and advertisement. So, 14. Computer programs. And lastly, 15. Other literary, scholarly, scientific, and artistic works. All of these 15 are what copyright covers. So if there are these things, to be exact, are covered by copyright, so there are also things that copyright does not cover. And those are: copyright doesn't cover ideas, procedures, processes, systems, methods, concepts, discoveries, facts, claims, titles, and short pieces, typeface. Okay, some may ask questions why these are not covered by copyright. It is because copyright protects expressive content, not the underlying ideas. Ideas are part of the public domain, and therefore no one can have a monopoly in that idea. So these are the examples of copyright. As you can see, we have here this. So this is a symbol of copyright, C inside the circle, and the word copyright itself.
Next is the guidelines or general rule on online use of copyrighted materials by Smaldino, Lothar, and Russell. Number 1. Contrary to popular opinion, all material on the internet is copyrighted unless stated otherwise. It is copyrighted even though it does not display the copyright symbol. So the first general rule of online use of copyrighted material is we must treat all materials on the internet copyrighted even though there is no symbol of copyright displayed. Number 2. An email is an original work fixed in a tangible medium of expression that is covered by copyright. Hence, it is recommended that you should not forward any email without permission, in consideration of both Copyright and Privacy Act. So since email is an original work and also it is covered by copyright, then it is recommended that we should not forward any emails without permission from the owner. Number 3. Downloading an article from a newspaper's website, making copies, and distributing them to your students prior to a class discussion on a topic is permissible, following the current photocopying guidelines, which permits making multiple copies for classroom use. Number 4. You cannot post students' essays, poems, or other works on the school websites unless you have permission of the students and their parents or guardians. Number 5. Educators should treat copyrighted materials from the internet the same way they do to print formats. So, let's treat copyrighted materials the same way to print formats. Give proper credits and also ask permission from the owner. So next is copyright infringement. It is the use of works without permission where the copyright holder has the exclusive right to reproduce, distribute, or perform the protected work, or to make the derivative works. For example, I will upload music or video on social medias, but after that, my uploaded video or music has been muted. Then, there's a possibility that there's a copyright infringement occurred. I uploaded the work of other without asking permission from the copyright holder. So let's proceed to plagiarism. Plagiarism is the copying the work of another and claiming it as his or her own idea or without proper attribution. Or shall we say, stealing of an idea. For example, we get an essay on the internet, copy-pasted it, and submit it for a school activities, then we can call it plagiarism because we claim it as our own work. So that's why we must be careful on using materials from the internet to avoid this. So we all know that copyright infringement and plagiarism has a similarities, but also they have differences.